Hi, I'm Emma Smyth, Associate Director at MKB Law, and I'm here with my colleague Gordon McElroy.
Hi Emma.
And we're going to have a chat today about Section 76 planning agreements.
Which I'm sure everybody is on the edge of their seats to find out about.
Indeed, riveting content ahead.
Well, Emma, you've been acting for developers in housing schemes. Are you coming across them often at the moment?
They're becoming very common at the moment, especially with the affordable housing requirement that's being imposed on developers.
Oh, so has that actually become a thing in Northern Ireland now, the affordable housing policy?
Yes, in some of the councils where our clients would have housing developments, even where the developer, for example, already has a planning permission, but they seek to go in and make a change to that planning permission, be it a change of house type, that will trigger the...
Really? Something as small as a change of house type is triggering the social and affordable housing policy?
It is, yes. So that's requiring the developer then to set a stock of housing aside for the affordable and social requirement.
And what sort of terms are they writing into those agreements?
That a percentage of the units have to be set aside for social, affordable or intermediate housing. And what we're seeing is the council will require the developer to, at a certain point, have those affordable houses ready for occupation. So, for example, if it was a scheme of 26 houses, there would be a trigger. For example, we're seeing between 50 and 70% of the stock.
So if I understand you correctly, you can't just leave it to the end of the scheme before you have to make the social and affordable housing available. You actually have to do it as you're going along.
Yes, that's correct.
And what happens if you can't get somebody to take up occupancy of those units? Is it an occupancy related condition, or is it just that you have to make them available? Available
for occupation is what we're saying.
Okay, and I suppose maybe we've rushed ahead of ourselves a bit. We haven't explained to anybody what a Section 76 agreement is, so let's take a step back and just tell me what a Section 76 agreement is and where it comes from.
So the Planning Act Northern Ireland from 2011 allows the local council to enter into a legally binding agreement with the landowner as part of the grant of a planning permission for development. And usually we would see Section 76 agreements used when it's considered that a development will have a significant impact on the local area that cannot be moderated by a condition contained in the planning permission.
There's a very good point in there, which is obviously planning permissions can contain conditions. So why would the local authority use a planning agreement rather than just put a condition in the planning permission?
Well, that is a good question, because any of the planning policy statements that we see would outline that councils should impose a condition first approach, whereas what we're seeing in reality now is more and more Section 76 planning agreements in play.
So do you have the sense that local authorities have become quite precautionary about whether to use a Section 76 agreement or impose a planning condition?
I believe they have, given the volume that we see coming through on the newer schemes that we're dealing with.
And what sort of requirements are you seeing in Section 76 agreements? Obviously, there's the social and affordable conditionality. Are there other planning gain type conditions being imposed?
Well, for example, a big one that we would see is the infrastructure. So if there's road works, junction works, upgrading to public pathways, for example, we would see those sorts of obligations by way of a Section 76 agreement.
And does that mean that money's then just having to be set aside out of the scheme in order to fund the public works?
Yeah, so there's a couple of different options that we would see. So there might be that the developer has to make a contribution to the local authority for the local authority to do those works.
Yeah.
or they might ask the developer to do those works, and the developer then would have to cost that into the own cost of their project.
Okay. And does anybody monitor whether or not this is done?
Yes, so as part of the Section 76 agreement, the council monitor it, and they impose a monitoring fee on the developer.
Oh, so they charge you?
Yes, so they not only are imposing this obligation that certain things have to be done by the developer, which comes at a cost, but they also charge the developer for the cost of making sure that they are compliant with the terms of the agreement.
Okay, that feels a bit unfair. So you have, as we've said, social and affordable, then contributions that developers have to make towards schemes. Anything else that...
I was involved in one a couple of years ago, obviously with the rise of the student accommodation in Belfast.
Yes.
And the council were trying to implement greener transport measures. So the developer in that instance has to provide travel cards for 18 months to each of the occupiers of the accommodation. But in addition to that, had to also offer a car club scheme. Where there was a couple of cars available where they could use, which you would see in larger European cities, but it's definitely going to come into effect here.
Oh, that sounds very proactive, but good luck to the council in monitoring that. And I suppose that's right, that's somewhere where we are seeing Section 76 is in the transition to the green economy and making transport facilities available. I can think of a scheme outside Lisburn where that was imposed as a condition. Obviously, you're then acting for developers selling these schemes to the end users, to the house buyers. Does the existence of a Section 76 agreement have an impact on the way that those transactions take place?
Generally, your Section 76 will appear on the statutory charges register, which obviously a buyer's solicitor would be entitled to request from the developer's solicitor. We would then provide a copy of the entries on that search, which would include a copy of the Section 76. For example, if there was a requirement to do something at the occupation of the 50th house, for example, you would see queries asking what stage is construction at, how many houses have been occupied, to ensure that.
And can you give me an example of the sort of thing that might be? Could it be industrial units or?
Yeah, or even roadworks or junction works. So for example, if there's going to be a large development and it's going to be occupied, obviously there'll be more pressure on the infrastructure surrounding that scheme.
Rathgale Road in Bangor would be a good example of that.
So the planners might seek to impose a condition that they have to have certain works completed after a certain number of houses have been constructed.
And it's very important, and it's an important negotiation, I imagine, whether or not the condition relates to the construction of houses or the occupancy of houses.
Absolutely.
Because you can control one much more than you can control the other.
Yes.
And do you find flexibility with the local authorities when you're addressing those issues?
They usually have it decided. It will usually be occupation is what we're seeing at the minute. That's not to say it won't change in the future. And obviously if it was to be constructed, that would have an impact on the schedule.
Yes, and construction at least is within the developer's gift.
Yeah.
You can't force people to buy houses.
Absolutely.
So you're going through the planning application with your client, and it becomes apparent that the council will require a Section 76 agreement. Where does that fit into the process of getting the planning permission?
Yes, so some people might think that the planning agreement would come after the event of issuing the planning permission, but actually it's a material consideration in deciding whether to issue the planning permission, and therefore what we're seeing is the terms of the Section 76 planning agreement is agreed in advance of the planning permission being granted at council.
So is it the case that the council sends you their Section 76 agreement and you have to have that approved by your client?
No, the developer's solicitor would initiate that process. We would send out a form of Section 76 agreement for review by the council.
And are those all standardised across Northern Ireland?
No. Each council will have their own form of wording which they prefer. It would be much easier if there was.
It certainly would be, yeah. So if I was in Belfast, my Section 76 agreement could look different to if I was in Newtownards.
Absolutely, and that's the challenge for developers. You know, if they have a couple of schemes ongoing across different council areas in Northern Ireland, different reporting obligations, different triggers for certain works to be completed. On top of that, they're having to inform the council about when certain things have been completed, and on top of that, paying monitoring fees. It's a huge burden.
It is. Sounds like a burden. Of course, we could talk for a week about the inefficiencies of the governance of Northern Ireland, but we'll not go down that particular rabbit hole. You told me that the planning agreement has to be agreed before the planning permission is issued. How does that work? Where in the process then do you actually get round to signing this Section 76 agreement?
So usually the council will agree to grant planning permission subject to the planning officers agreeing the terms of the Section 76 with the developer.
So they give authority to the officers to
Yes.
work out the Section 76?
They delegate authority to the planners to negotiate the terms of the Section 76 with the developer, and once the planners are happy with the terms of that Section 76, they will grant the planning permission.
Once it's all been signed up?
Signed up, yes.
Yeah.
And the effective date then of the Section 76 will be the date the planning permission is issued.
Okay, so that's important, so that the landowner doesn't get bound by the agreement before the planning permission is granted, or even if the planning permission was turned down eventually.
Exactly. So it's only effective once and if the planning permission is granted.
Very good. Very good. Okay, Emma, thank you very much. I'm sure you're being kept busy with these.
Indeed, it's a good area of work to be involved with.
That's great. That's great.
Thank you.